about a reasonable time for her to get out. You've had to go through this. I don't want to hear from you right now because I'm going to get up and leave this bench because I'm not happy with any of you. What did I just say? What did I just say?
Before a single word is spoken in this courtroom, you can already feel the tension boiling over. This is not a clean landlord-tenant dispute. This is family, emotions, blurred boundaries, and resentment colliding inside a legal system that does not care about feelings, only facts. At the center of this case is a daughter who moved into her parents' home under stressful circumstances, and parents who now say that situation has spiraled out of control. Accusations are flying, trust is gone, and everyone seems convinced the other side is the problem. What makes this case so compelling is how fast things unravel. There's no written lease, no clear timeline, just assumptions, misunderstandings, and escalating fear. One side feels unsafe in their own home. The other feels trapped with nowhere to go. And standing in the middle of it all is Judge Simpson, trying to impose order where emotions have completely taken over. Watch closely because this case is about more than eviction. It's about what happens when family tries to handle serious problems informally, and the law has to step in to clean up the mess. Who crossed the line first? Who misunderstood their legal rights? And who is about to learn a very hard lesson about what the court will and will not tolerate?
English?
Yes.
All right. Go down that side. Snyder?
Oh.
All right, come on. Yes, come on. You're over here, waiting. Just right there.
Over here.
Yeah, right there. All right, this is a termination of tenancy case, and folks, what's going on?
We moved her in because she was getting evicted from her other residence. Her husband moved out on her, and we allowed her to move in without no lot rent, no fees, and she come out one morning and started taking pictures of me, implied that I was stalking her. I feel uncomfortable with her being there.
Okay. All right. What's the relationship between the parties? Any?
She's the daughter or friend of my wife.
That's why we allowed her.
Hold on a second. Okay, so who are you?
I'm his wife. I'm also on the lease. That's why we allowed her to move in. We're trying to help her out. She's been there 3 months.
Okay, hold on.
Had
Just
a physical altercation.
all right. So, still trying to figure
It's
this
just
out.
a bad situation all the way around.
Okay, that's not what I was going to ask. Who is she related to?
She is my daughter.
Thank you. That's a simple answer I was looking for. All right. So your daughter moved in because you got evicted from your other residence. Is that correct, ma'am?
That's not correct.
Okay. So what happened?
I was living at another residence with my husband at the time, and he was abusive with me, so I had to separate from him, and then he left the house. He was being evicted. I wasn't on a lease at all. But
Got it.
I was going to put on there, and then they allowed me to come with them and stay for, I said it was just temporary. I just needed like a little temporary. I wasn't going to be there forever. I just needed to figure out
What you were going to do?
yeah, because all what I was going to do got messed up, you know, like with everything. And
Okay. And
he has been very inappropriate, the way he acts around me.
This is the emotional heart of the case, and also the most dangerous moment legally. Allegations of inappropriate behavior instantly raise the stakes, but notice what the judge does next. He doesn't react emotionally. He doesn't accuse. He refocuses the discussion back to what the court can actually rule on. That's intentional. Courts cannot act on vague claims without evidence, reports, or charges. And while the daughter clearly feels unsafe, the legal question remains unchanged. Does she have a legal right to stay? This is where many people misunderstand the system. Feeling uncomfortable does not automatically create legal protections unless specific legal steps are taken. At the same time, from a human perspective, this is deeply uncomfortable. Living in a home where you feel watched or restricted would shake anyone. So ask yourself, if you were in her position, would you have stayed or would you have left sooner to protect yourself?
I can't even take a shower in that house. I can't do laundry. I always have to have my phone because I don't feel comfortable.
Okay.
And then she called the cops on me after that and said, "You're not locking my husband up, B-word." I got that on recording.
Okay.
That day.
All right. So, but you don't have a lease there, correct?
No, I don't. I don't want to stay there either.
Okay.
You know that.
So, when did, ma'am? So when are you going to leave?
As soon as I can. I was thinking the first is probably the soonest I can.
Did you bring a lot of property with you?
I have a bunch of it in storage, and I have a bunch in that room in that house. And I have a dog and a cat, and they know that. It's really hard to find like a room to rent with pets, and they want $1,000 a month for a room.
I gotcha. So, when do you folks want her out? That's not happening.
Yeah.
What's a reasonable time for her to get out of the premises, from your perspective?
7 days.
Okay. By law, she at least gets 10.
This is one of the most important legal clarifications in the entire hearing. Judge Simpson immediately shuts down the idea of a 7-day removal because the law sets a minimum threshold. Regardless of frustration, discomfort, or family conflict, the statute controls the timeline. This is where many homeowners get themselves into serious trouble. You cannot simply decide someone needs to leave and enforce it on your own schedule. Even without a lease, once residency is established, the law requires notice. Period. And the judge makes it very clear. You allowed her to move in, you allowed her belongings, and therefore you must allow reasonable time to leave. Would you have expected the law to protect someone in this situation? Or do you think homeowners should have more power when family situations go wrong?
Okay, she can get 10.
What's the attitude with this? I mean, you guys moved her in. You realize the circumstance, at least she's saying that she was in, and you got to give her time to move out. You let her move her stuff in.
We did, but we wasn't expecting for her to start calling me a stalker and all that. I feel uncomfortable with her in my house now.
What would be a reasonable period in your mind for her to move?
10 days.
Okay. You guys can maybe sit there and think about what you're doing. Whether you like family or not, you got to deal with it that way. You let her move in. So think about a reasonable time for her to get out. You've had to go through this. I don't want to hear from you right now because I'm going to get up and leave this bench because I'm not happy with any of you.
Are you speaking?
What did I just say?
That's what
What did I just say? Court's going to stand in recess.
All right. What do you want you to speak?
You want to know what? You're going to be in contempt and you're going to go. You are not even a named party on this case. You might want to go out there and sit down.
This is where Judge Simpson draws a hard line, and it's not about the eviction anymore. Courtroom decorum matters, and when someone who isn't even a named party continues to interrupt, the judge makes it crystal clear, this will not turn into chaos. Contempt of court is not an empty threat. It's a real legal consequence, and judges use it to maintain control when emotions threaten to derail proceedings. Notice how fast the tone changes. One more word, one more interruption. That's all it takes. This moment reminds everyone in the room that regardless of family ties or emotional stress, the courtroom operates on strict rules. Do you think the judge handled this firmly enough? Or should he have been more patient given how emotional this case clearly is?
Go out there and sit down.
No.
Now.
No problem.
Now. Go.
It's your job.
Just go. One more word and you're out of here. One more word.
Right? No problem, ma'am. Don't think you go down, okay? Okay, I can turn.
We're back on the record in the case of English versus Snyder, and both parties are here. And I'm just going to try to resolve this because apparently the parties can't do it themselves, and I'm not going to try to use whatever water under the bridge. You're saying you want to the first?
Yes, please.
You are saying, sir, that you want our statutory time's 10 days and you're stuck on the 10 days.
No, she can stay to the first as long as she agrees to get out.
Okay. I appreciate that. All right. And that's a reasonable way to handle this. So what I'm going to do, it's a termination case. I'm going to grant a judgment for possession after hearing on this case.
This is the legal resolution taking shape. A judgment for possession does not mean immediate eviction. It means the court recognizes the homeowner's right to regain the property after the lawful timeline expires. That distinction is critical. Judge Simpson carefully explains what comes next, including the potential for a formal eviction order if the deadline isn't met. He's also doing something else here, preventing future mistakes. He explicitly warns against self-help eviction tactics, changing locks, restricting access, or intimidation. Those actions can backfire severely and expose homeowners to legal penalties. This is the court saying, let the system handle it. No shortcuts, no retaliation, just compliance with the law.
What the fuck's second?
The writ date, July 1. Okay. Now, so they can act so that both parties understand this, okay? On July 1, they can file what's called an order of eviction, or request for an order of eviction to have you forcibly remove from the premises. I don't think you want to put anybody into that.
No, I'm not even trying to get evicted. I don't have any evictions on my record.
Okay. You have to file with the court, sir, a judgment form, and you have to fill that out for my signature. Okay? So you can, I'll get you guys out of here. You can pick one up at the counter, file it with the court. I'll sign off on it. All right? That will give her until July 1 to vacate the premises. All right? Anybody unclear as to that? All right.
I'm not.
You're clear.
I'm clear.
Okay. For you, sir, I'm going to tell you because what you don't want to do, if you may want to inform your wife of this, is to in any way, prior to that date, try to do anything that looks like it's your own self-help in terms of getting her out. Okay?
Right.
Okay?
But she's still not allowed to have company over, right? She's in the past.
Okay, look, that's not before me.
Okay.
I can't. I do a lot to rule people's lives. I can't tell who's going to be. I'm not going there. Okay?
All right.
The only thing I can tell you is that as of that day, that's that. Okay? Now, I'll give a suggestion while I can't order it. Okay? Young lady, how old are you?
I'm 31.
Okay. You can like your parents, you can not like your parents, you can not do whatever. But when things got bad, that was somebody that gave you a roof over your head. Okay? And so it doesn't mean you even have to talk to them. But I think it's sometimes important, and I think I'll call you a kid because you are somebody's kid, right?
Right.
That these days, sometimes they're just not respectful of that. So while I'm not ordering it, I just say to you, just be respectful. They don't want you
I've
to
been
have.
trying to be, and like the whole time I've been there and followed all the rules, and they let me have one person over, only one person per company, and then they took it back after all that. They're like trying to.
Okay. Well, but I get it. But this, you know, what you guys are telling me are what parents and kids have been dealing with forever, right? And so, you know, when my daughter stays with me, I can tell you, she's thinking I'm changing. I'm thinking to myself, that's what I said all along. But from her perspective, I let this happen and then I changed something. I didn't change anything in my view, but I get it. Okay, so you know, just do it and try to work through it. Okay.
I'm trying.
Okay, and the same thing for you. Just try to work through it. Sometimes it's better if all of a sudden at one given moment you want to say something, just don't say anything. Count to whatever. Just don't say anything. And then maybe 30 seconds down the road, you're not quite as unhappy about it. You just try to figure it out. Okay?
I gotta get some kind of form.
Yeah, you got to get paperwork. Ask them for a judgment form.
Judgment.
At the front counter. All right, and then you just got to fill that out. Okay?
All right, thank you.
All right. Thank you. So I can trust that you two will walk out of here peacefully and not
I won't knock her.
go at it in the hallway. Huh?
No.
Either, but just can you two walk out peacefully, or do I have to have escorts?
Just
All right.
right there.
Then here you go, and you sit there. You sit there, and then we'll get you out. Okay? All right. Do I have anything else? I don't have any.
In the end, this case wasn't about choosing sides, it was about restoring order. Judge Simpson balanced legal obligations with human reality, giving the daughter time to relocate while protecting the homeowner's rights to reclaim their property. The ruling reinforces a powerful lesson. Informal family arrangements still carry legal weight, and emotions do not override statutory requirements. This courtroom moment shows exactly why clear boundaries and written agreements matter, even with family. When those boundaries blur, the court becomes the final referee. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.